All right, so here we are looking at Bodies and Evidence by Heather Hlavka and Mulla. This is the first lecture, first chapter, um, called Common Sense and the Nomos of Sexual Assault. They start off their description of jury selection with what they call the nomos of sexual assault. That is, the norms, cultural conventions through which potential jurors come to understand sexual assault, especially in the privileging of medical legal interpretations of sexual assault. We'll see that on the part of the prosecutors and defense attorneys, this involves a delicate play of trying to shape jurors. So educating them not always in the same way, because of course prosecutors and defense attorneys have different interests. So they can be contradictory in ways, but still trying to educate them, shape them in particular ways. But at the same time, trying to be responsive to the jurors themselves, to their perceptions of race, gender, and forensics. So they're trying to anticipate certain things among potential jurors, get a read on potential jurors, and try to educate them to become a particular kind of juror, particular kinds, I guess, depending on whether it's the prosecution or the defense. The voir dire stage of selection, voir dire being the stage where the attorneys and also the judge, but mostly it's the attorneys, will pose questions to potential jurors to get a sense of who should be included, who they would like to be on the jury, who they would like to exclude, who seems like a poor candidate for a juror, and so on. So this stage where they have all of the potential jurors before them, and they are asking them questions, again, like trying to sort of take their temperature, get a read on them. At this stage of jury selection, there are these competing tendencies around the topic of common sense. Jurors then are called on to exercise their common sense, so that if, for example, they're possessed by prejudices that would impair their use of common sense, then they may be excluded. At the same time, though, common sense often bears with it a number of myths about rape. For example, that it is usually committed by a stranger, that there will always be signs of struggle or injury, that should a victim delay in reporting, that maybe signals a false accusation, so that common sense can be double-edged. Further, there are circumstances in which these kinds of myths can work in the favor of prosecution or of defense cases, not in the same ways, obviously. And so one of the things that we find is that they seldom decisively contest the rape myth side of common sense in the course of voir dire. They do contest it, but it's generally not decisive. Hlavka and Mulla maintain, therefore, that, quote, the nomos of sexual assault is evidenced by attorneys, judges, and jurors in the act of anticipating, eliciting, imparting, interpreting, and privileging certain characteristics and common knowledges. They'll explore nomos as it appears in the voir dire stage in three ways. And so I'm not going to give a comprehensive account of each of these three ways. I'm just kind of trying to give you points of orientation as you read through, so that you can kind of track what's going on in the chapter. The first two are around race and sexual assault, are these difficult to talk about subjects. The third, forensics, will be a different story. Their talk is straightforward, but that doesn't mean that it's not fraught. There are problems to be addressed there. How demography, so this is the first one, how demographic questions, of potential jurors allow attorneys to use geography, say zip code, neighborhood, as a way to probe, albeit obliquely, intersecting issues of race, gender, and sexuality. Second, they chart how attorneys' questions frame sexual assault, raising the paradox of sexual assault as so disturbing that it is nearly impossible to discuss, while also preparing jurors for the reality that they're going to hear testimony about this hard to listen to, almost indiscussable topic. And then finally, as I say, forensics. We get to forensic evidence. Judges and attorneys would attempt to assess jurors' racial sensibilities, largely and understandably using indirect means. Of course, asking questions like, are you racist, is not going to get a useful response. So, and of course, race and racism on the whole are very charged topics, and so they would use these kind of indirect oblique means. For example, extrapolating jurors' social worlds from their neighborhoods and their employment status. Residence here stands as a marker for race, class, and politics, all of which are issues of concern for judges and attorneys who are concerned about impaneling a fair and impartial jury. All of them are, especially given the disproportion of Black men arrested, tried, and incarcerated in Milwaukee. So then using residence as a sort of proxy in this way was a tactic attorneys used to assess jurors, given the difficulty they often encountered in getting them to talk openly about sexual assault. The concern attorneys had about racial bias tipped both ways, both around concerns for the defense and for the prosecution. For the defense, there's the concern about presumptions of guilt for a black or brown defendant. But for witnesses, there is the concern that jurors might place little faith or little trust in the testimony of a black witness victim. The issue, especially according to one of the attorneys that Hlavka and Mulla talked to, is that race outweighs everything else. That it amplifies the challenges on either side in the way that nothing else does. Still, though, at the stage of voir dire, this is difficult to raise directly because it's difficult to solicit people's to solicit their biases in a frank kind of way, if they hold biases. And so attorneys would even find themselves apologizing to jurors for raising questions of racial prejudice at all, saying that it was an unfortunate but necessary task. So they conclude then. Attorneys adopted a range of techniques for determining the racial sensibilities of jurors. They subtly solicited information about community and neighborhood, extrapolating what they could from jurors' home addresses and occupations. Now, attorneys and judges often approached sexual assault as an unspeakable and lifelong trauma that could impair the impartiality of jurors who had experienced it themselves. So the authors say, When some jurors responded that they could not be impartial and serve on the case, it demonstrated for the court and to other jurors that sexual assault was a potential source of lifelong suffering that affected victims' capacity for judgment and rationality. As judges signaled their own sensitivity to jurors' discomfort and unease, they were among the first court actors to frame sexual violence through cultural norms that imagine it to be so traumatic and shameful that it is rendered unspeakable and unhearable. Attorneys would then try to learn about jurors' experiences and sensibilities, again through indirect or hedging questions. So they wouldn't just ask about the individual jurors sort of in isolation, but they would frame their questions in terms of, have you or a close family member or a close friend experienced sexual assault? Have you or a close family member or a friend been accused of sexual assault? Has someone close to you been tried for sexual assault? And so on. So that the jurors then could respond without necessarily having to identify themselves as having experienced sexual assault. But the other thing that asking in this way does is that it recognizes the communal impact of sexual assault, so that whether someone is a victim of sexual assault or accused of sexual assault, the implications may well be most pointed for them, but that they have an impact on those around them as well. In the case that they're considering in this chapter, the judge urged jurors to recognize that whatever experiences jurors or their friends and families might have had, they had to separate their feelings about those experiences from the present case, as if to say, that is not this case. Instead, they need to rely on rationality to reach their conclusions about the facts in this case. In the course of this sort of discussion of experiences and perceptions of sexual assault, prosecutors find one of few opportunities to educate jurors about rape myths, like how a victim should appear. Is there a way that a victim should appear? Whether there must be injuries. What if there are no injuries? Whether, or at least no visible injuries. Whether a victim delaying reporting indicates untruthfulness, right? So all of these things that, as I said before, are frequently elements of common sense, but are built on myth. Finally, discussing in general terms some of the testimony that was likely to be presented during the case, not only worked to identify jurists who might not be able to might not be able to bear hearing such accounts, but also started the work of desensitizing jurists so that they would set aside personal feelings and in their place rely on legal criteria, right? So it's kind of like, you can think of it as almost like a process of conditioning jurors to be able to withstand testimony that they would find deeply uncomfortable to hear. All right, last section. So they open this section by saying rape myths not only informed attitudes about race and sexuality, they also informed juror attitudes about forensic evidence. And as we'll see, the desire for forensic evidence is often weighted against the trust that jurors will put in testimony. Jurors, prosecutors claimed, often labored under what they call the CSI effect, according to which jurors expect certain kinds of forensic evidence in sexual assault cases, in particular DNA, and it fell to attorneys to do this educational work to explain that often there was no DNA evidence. And sometimes even if there was DNA evidence, its presence might not be all that indicative of anything. So that if, for example, you're talking about a defendant and a victim who live in the same place, then it would make sense that there would be both of their DNA throughout that place. And so it may be difficult to draw real conclusions about the presence of DNA in those sorts of cases. Further, the expectation of and faith placed in forensic evidence like DNA, as I was saying, came at the expense of trust in testimony, despite the fact that in many of these cases, testimony was going to be all or perhaps the primary evidence that the jury would get to hear. They say then, the nomos of sexual assault has come to rely heavily on medical and forensic knowledge, so that forensic intervention is both imagined and foundational to sexual assault adjudication. And they cite here a paper where they've discussed that in the past. We contend that medical legal forensic evidence is imagined because it most often does not exist. Yet, it is simultaneously foundational because juries might expect its presence and draw on it to form conclusions about victim credibility and testimony. Now, although attorneys might try to sort of educate jurors out of certain preconceptions about the importance of, say, DNA evidence, they might also play on rape myths that lend themselves to the weight of forensic evidence, so that if it is the case that a prosecutor has DNA evidence, however weak that evidence might be, the prosecutor might play that up. And on the flip side, of course, if a defense attorney is faced with a case in which there is no DNA evidence, the defense attorney might play up the absence of any forensic evidence of that sort to try and sort of throw jurors back on their distrust of testimony alone. And so these sorts of appeals to jurors' common sense notions about forensic evidence simultaneously brought out their distrust of testimony because testimony then just is not one of the constitutive features of their common sense. Their common sense tells them forensic evidence is the gold standard. The other thing that we'll see here then is that in this sort of course of educating jurors, trying to shape them in particular ways, defense attorneys may actually start to employ defense tactics during voir dire. So before the course, before the case has formally started. So, example, by placing stress on the meanings of reasonable doubt, the burden of proof, in the context of juror skepticism about the reliability of testimony. They say, defense attorneys' appeals, while in the best interest of their clients, contributed to a false dichotomy in which rationality aligned with forensic evidence and emotionality is associated with testimony. Introduced at every jury trial we observed, these three filters during jury selection, racial sensibilities and prejudice, experiences of victimization and accusation, and forensic expectations, provided jurors with a very complex set of reference points through which to navigate their deliberations over guilt or innocence. So they wind up packaging this broad set of claims in this chapter in this way. To select a jury during voir dire, attorneys relied on honest responses from jurors, but attorneys were also concerned about those who remained silent through the process. By staging demonstrations, introducing relevant and sometimes competing frames of reference, and even provoking involuntary responses, attorneys sought to draw out jurors and prepare those who would be selected for the task of deliberation. While attorneys and judges were generally concerned about jurors' fairness and racial sensibilities, they also used voir dire to explore jurists' experience with and attitude toward sexual violence and forensic intervention. As they posed question after question, they were able to glean some information about the potential jurors while also imparting their own. We've demonstrated how the process challenged rape myths, but also left them intact. And this is where we wind up with the end of chapter 1. Okay, thank you.